Welcome back. This face-to-face on Channel One Television. My guest is Joseph Kpemka. He's a lawyer. Some nearly 20 years ago when you became a lawyer, at the time admissions weren't a big issue. Not so many people would go and write that exams and go to the law school. I think it was just a few faculties or few universities that were offering.
In fact, 2 faculties.
So it was KNUST
yes.
and
that was just the first batch of KNUST.
And Legon. When you became a lawyer. Yeah. Today, though, we have so many faculties and admissions into the Ghana
At the time
school.
I was leaving the General Legal Council, there were about 15 or so across the country.
Okay.
Yeah.
And I'm sure it has increased. Now, when you were called, I'm sure you were around 100 or a little over 100.
Yeah, we're just about 200, I suspect. But now they're in thousands,
They are in thousands. Yeah. And so it's talking about expansion of legal education. So there's one proposal that open up by building more infrastructure. In fact, yesterday, the Director of Legal Education was in Kumasi, where Otumfuo has given land for the building of a new campus for the Ghana School of Law. That's happening. There's a campus at Gimpa, there's a campus at UPSA, then there's Makola, which is a traditional one. There's another view now that we are hearing from the Attorney General, Dr. Dominic Ayine, which may suggest that we may not even need that kind of expansion, that the faculties are going to end up becoming the law school where people would be trained and then they go prepare for the bar exams. You are a lawyer in practice, and you also, I don't know if you've taught before in the law schools. I don't know what your view is about expansion in legal education. Should it be the approach we currently run, the bill that the minister is proposing? Is that the solution to all the issues? I don't know what's your view.
Thank you very much. I've had quite a number of interactions with very prominent people and very senior lawyers on this topic. And it's a delicate balance one has to draw in this matter. Not write off completely the current one and not also discount what we are about to do. So there must be a delicate balance. And I'm saying this because care must be taken in order not to churn out persons who, quote unquote, will be legal charlatans that will undo all that we've done over the years. I'm saying this because I've been privileged to be a member of the General Legal Council, and we reviewed certain faculties across the country. And some of the faculties, to be very honest with you, fell below expectation, even in running the LLB program.
Okay,
in terms of
even the fundamentals.
Yes, even in terms of infrastructure, in terms of staff strength and qualification, in terms of student, how they get into the institution and all that. Because some of the faculties, to be very honest with you, all their intentions are actuated by money. And so if care is not taken, we will actually destroy the very foundation of legal education. And when you get that wrong, everything else will come crumbling. So I agree that we need to expand it, but we need to hasten slowly. If we have to say that faculties will be empowered to run professional law courses, then we have to caveat that, and we give conditions that will qualify you to run it. Otherwise, if you open it up and say every faculty that has been licensed to run LLB should also be licensed to run the professional course, we may in a few years come back and bite our fingers hard and try to review it, probably belatedly. So I am advising that, yes, it is good to expand it. It is good to decentralize. And it is good to have it as we have in other professional bodies. But there must be some regulatory regime that will ensure that quality is not compromised. Because if we churn out unqualified lawyers into the system to go and deal with people's lives, you are as well an accomplice to murder. Because those people will become so dangerous to society by the legal services they are providing. So quality mustn't be compromised at all.
But when
I agree.
But when you argue the way you argue, there are people who say those of you who have become lawyers have made the profession a preserve for the few. You are conservative. You do not want to open the door for others to enter. And that the expansion is necessary because we don't have enough lawyers in the country, and that you are preventing people from becoming what they deserve.
Omaru, I have said it, that the expansion is very necessary. That is my actual preliminary remark. The expansion is necessary, but I'm saying that we should do so cautiously in order not to compromise the very integrity of the profession. That's the argument I'm making.
But doctors deal with human lives.
Yes.
Do we have the same restriction we have in training doctors like we have in training lawyers?
I think so, even if not stricter, because you see, people go out of the country and read medicine. When they come back, they go through rigorous processes before they are admitted.
They do licensure exams.
Absolutely. They do that. And that is meant to ensure that quality is not compromised. Look, Umaru, in our haste to train more lawyers, if we are not careful, I'm saying that we will regret and come and sit down and then try to review it and go back to older systems. So what I'm saying is that it is good. I support it. What the Attorney General is doing, I support it. But I'm saying that we must caveat it seriously by saying that each faculty that wants to run the professional course must meet a certain criteria by way of staff, library, accommodation of faculties, and etc. Everything. We must give very strict qualification criteria so that if you don't meet that, then your students who qualify can go and register in another institution that meets the qualification criteria to pursue.
I spoke to Ansasari. He says that even the lecturers should be made to be practicing lawyers and not necessarily someone who holds a master's in law or a PhD in law. A lecturer should be someone who has a practical knowledge. I don't know if you agree with that.
No, I think that is a very good argument he's making, and I support him. Sometimes we so much pay attention to academic credentials, to the neglect of the professional training that we are. I told you this morning that I have met people who got third class in the law faculty and who are lawyers par excellence today in our society. Far, far better than people who got a first class. So legal practice is one of a practical nature. It is not an academic exercise. So if we will have to ensure that there is quality, then there's nobody else who is more qualified to teach somebody to become a lawyer than the practitioner. If you want to be a very good medical doctor, you go and learn under a very good medical practitioner who has gone through everything. He has corrected himself and made some mistakes in the past. He knows what to do at each point in time and all that. That is very important. So if you go and then the qualification criteria is that go get master's degree or go get PhD before you come and you lecture in the law, and there's somebody who has first degree and professional law qualification with so many years experience and everything is at the fingertips. And when you ask him a question, he doesn't blink an eye, he just pours everything out. You leave that person out by virtue of caveating that he has no PhD or master's degree. Of course, you're not doing the profession any good. So the argument I keep making is that I agree with my very good senior, the Venerable Ansasari, that it is necessary to look at that again, because by and large, we are not training people to, as lawyers, they are not academics. They are professionals who ought to affect the daily lives of their clients and people. So we have to rethink. And let me state this, if it hasn't been clear and loud, that the expansion bit that you've spoken about, I support it. I support what the Attorney General is doing. But again, I'm saying that it ought to be done in such a way that it doesn't become omnibus and automatic, that any faculty that is running LLB will run the professional course.
So the draft bill, he says, will be taken to cabinet. Perhaps when it comes out in the public, we may see it.
And we will all make contributions.
Yeah, then you can make all make contributions. But again, it means that there will be no Ghana School of Law. I don't know what that means. And because, so if you went outside Ghana,
I think the Ghana School of Law can remain. And this is how I see it. That it will be like when you have finished your LLB, you would decide not necessarily to continue in the school that you were in.
Yes.
So you can decide that, okay, I finished LLB, I'm going to Ghana School of Law. So the Ghana School of Law will still do the professional training.
That's what we have now, and that's where the problem is.
No, the person can, and at that time, because the faculties are many that are running this, the Ghana School of Law will not be able to do the restrictions they are doing now.
So Ghana School of Law becomes a competitor.
It will become a competitor.
So it will be the sole admitter.
But we are not going to have a body that will regulate the conduct of the exam.
Including the School of Law.
Yes, including the School of Law. And I believe where it also happens, the School of Law will introduce a new system where they will admit LLB students. Most likely, that's what I see. They are likely to now start admitting LLB students that they will train throughout.
So they become a faculty.
They will become a faculty, sort of.
Okay.
You know, because that's what I foresee. Otherwise, if you do it, and at the end you still allow the Ghana School of Law to superintend and dictate everything, as long as then it means that the decentralization you are talking about and the way you've tried to actually ensure that it spreads across board will be defeated.
There are members of society who think that lawyers are a problem. What do you say to such people?
They have to clarify that statement because it's too strong
they say,
in general.
They say everything is law, 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 law.
No, I think I agree. Immediately we lose it. If we decide that we are going to move out of law, then we are going to live in a society of men and might, and we know that we are going to retrogress 1,000 years backwards. No matter how benevolent a person who administers me or society is, he should not be allowed to do so in his discretion. It should be guided by rules and regulations. Otherwise, when he gets too excited that everybody is hailing him, he'll become a monster.
And now we talk about law, 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 and we've heard that the law is the law. It's a general refrain people are using now, and it's in reference to the Chief Justice who has been suspended now. When you were Deputy AG, she was at the bench. She wasn't the Chief Justice at the time.
Yeah.
But after you left, she became the Chief Justice. The removal process of Chief Justices is stated in the Constitution. This government says to the best of their knowledge and ability, they have followed the process. People from your party are saying that it is witch hunt. She herself has said she's not been treated fairly. You have been following the proceedings. What's your view on the impeachment process?
But let me state this today. I haven't commented on this Chief Justice's removal since it started, okay, the process of her removal. But let me make this clear, Umaru. You can give fidelity to the law and yet create mischief.
Okay, explain that.
Now, if the Constitution gives a process and you follow the process through, you are abiding by the law. But you can, in the course of abiding by the law, use the law to do mischief. And let me give you an example. The removal of the Chief Justice. Umaru, did you follow the election of the Council of State member in Ashanti region?
I followed the election of the Council of State members nationwide.
No, I'm talking about Ashanti region. I want to draw your attention to something.
Go ahead.
In the Ashanti region, the first time they held the election, someone was elected. And there was a protest led by the regional minister and other people. Why? Because the person was said not to be a member of the National Democratic Congress. That's a fact. He was a known member of the New Patriotic Party. Somewhat, they got the results nullified and then organized a fresh election. And then the one who won the election was their choice. What does that tell you?
It tells you that you cannot bring foreigners to come and advise you.
Thank you very much. So in the end, you have members of your party or those who sympathize with you who are members of the Council of State. Now the law says that you refer it to them to determine whether there's a prima facie case. If I'm a president and I want the Chief Justice removed, I'll direct the Council of State that they should determine the prima facie and say that the person is has a question to answer. And once there are people who are my favorites...
Even though these are independently elected Council of State members?
Yes. Once there are people who are, accustomed to my side of the political divide...
Well, so 16 are elected and some are appointed?
Yes, I'm saying so. But I'm just telling you that the majority of them who are elected, in fact, all of them who are elected across the country, I can say without a shred of doubt, that the 16 who were elected across the country are members of the National Democratic Congress, unless they want to...
And this is not the first time this happened?
It's not the first time. It has happened under MPP, it has happened under NDC. And then after His Excellency the President has the opportunity to appoint. The only place where his choices are limited is a constitutional injunction. For example, he has to appoint a former Chief Justice. So that one, he has no choice.
Mm-hmm. A former IGP,
A former IGP and all that. Go and check the former IGP he appointed. He was IGP under which regime? Go and check.
So you're drawing some connections.
Yes. Go and check.
So for you, the Council of State is a shadow of the governing party.
That is my opinion. Somebody can take me on, but that is my opinion. Over the years, that's what I see. People decide who should come and advise them, and I've never heard that.
But
you decide who should come and advise you.
It's not proper.
Look, let me tell you, if you want the best advice, take it from a mix of those who like you and those who dislike you.
So, for instance,
But if it is a unanimous group that comes to praise, sing, and give you a chorus, then even if you are wrong, none of them will tell you are wrong. They will all say you are right.
So does your...
And remember that a former Chief Justice dissented. She even decided that she was not interested in it. So what I'm saying is that having gotten the Council of State to determine a prima facie case against the Chief Justice, now who is the one who nominates the members of the committee that is supposed to inquire into it?
The President.
So it comes back to the same thing.
So for
then
you,
the President goes ahead to nominate 2 justices of the Superior Court of the Supreme Court, one of whom the current the suspended Chief Justice says had sat on one of the cases that led to the, I mean, of course. And then one of them too, curiously, I don't know whether you detected that, there was supposed to be a motion that was supposed to be heard earlier. She was part of the panel. On the day of the motion, he wasn't there. Then, 2 days later, he was appointed into that committee, along with others. You know my good friend Domelevu. He's a member. You know him.
He was Auditor General.
He was Auditor General. Who appointed him?
Independent minded.
Who appointed him?
Who removed him?
So that's very well. I like that. I like both who appointed and who removed. Okay. I like both.
Okay.
Then you look at the others. So you look at the committee.
So let me...
you think that, you see, because of the power given to the president to do these appointments, do you think the president, in all intent and purposes, will go and pick a vociferous critic of his, or somebody who's been taking him to the cleaners, and make him a member of this committee? So it is not. So
you're essentially saying that what is happening is due process is a law.
Yes.
But there is a but.
Yes. That's my opinion. In fact, I have stated this time and again that I'm for following the fidelity of Article 146.
They are doing so.
But it is being used in a manner that has a lot of questions for us to answer as a
But you cannot kill it. It's a constitutional provision. It's been used in the past by your...
So that is why I'm saying that what we need to do as a nation. But remember even that the determination of prima facie was not done until the Supreme Court took a decision on it and said that because it was talking about any superior court, the Supreme Court judge, any Supreme Court judge, there must be a prima facie determination by the Chief Justice, okay, upon the president receiving it and becoming a conveyor belt and all that. But it is not specifically stated what should happen in the case of removal of the Chief Justice. And so the Supreme Court decided that there should be a prima facie determination by the Council of State. And I'm saying that, look, you can give fidelity to the law and yet cause mischief. And I've said it to so many people, that the law can be used to cause mischief. And in this particular case, I've told you. So I think that we need to do a constitutional amendment and make it stricter. So should we elect our Chief Justice? Let me give you 2 examples. Look at how difficult it is to remove the president. And look at how difficult it is to remove the speaker. Not until recently, it was becoming like an impossible thing to have a particular party having 2/3 majority. So what it then means is that you elect the speaker, all right, but you cannot remove him because you don't have 2/3 majority, unless there's a bipartisan approach, in which case it is a unanimous decision by the 2 sides. That look, this person is very rare. So the removal of the speaker is near impossible. The removal of the president is near impossible. But when it comes to the removal of the Chief Justice, it's either beck and call of the president. And other constitutional heads. Yes. So we have not, and remember that we can do anything to the executive. We can do anything to parliament. But when we touch the judiciary, the very foundation of our democracy is gone. That's my opinion. So when we start playing politics with the judiciary, whether NPP or NDC, we start playing politics with the judiciary, that is the beginning of the end of Ghana.
This is Face to Face on ChannelOne TV. Joseph Kpemka, former Deputy Attorney General. We'll come back. I'll ask him now to comment on Nolly Prosequa, which Dr. Dominic Ayine, who was once Deputy AG, holding this position, actually he took over from Dr. Dominic Ayine as Deputy AG, and now he is the boss, and he's decided something, and Kpemka's party is not happy with it. I'll ask him as a lawyer and as a former prosecutor whether what is happening is wrong or not. Please stay. You're welcome back. This is Face to Face on ChannelOne Television. Also, one of the difficult to pronounce Latin words that has been making the headlines these days is Nolly Prosequa.
That is so.
I mean, you have learned it in school and you have practicalized it or practiced it as an Attorney General, and it is a prerogative only for the Attorney General, the Nolly Prosequa. Dr. Dominic Ayine has done the same thing you people used to do or you people did in the past, and now hell is raining down. Why?
Well, let me first refer you to Act 30 of 1960, the Criminal Procedure Act, particularly Section 54 of the Act, which gives the Attorney General the power to enter what is known as nolle prosequi. And when the effect of a nolle prosequi when entered is that the accused person is discharged. Now, what it means is that, Umaru, it is not an end to the matter. When the nolle prosequi is entered, it's not an end to the matter. It's a truncation. But the state can always come back at any time to reactivate that process and go on. But it's very rare that we find those situations. So the effect of a nolle prosequi is that the accused person is discharged. And the discharge means go home. You are not acquitted, but go home. Anytime the government thinks that they want to go back with you to court, they can always do so.
Sometimes they arrest them immediately outside the court.
Sometimes too, it is as a result of faulty charges that have been preferred. So, or they want to take you somewhere else. They discharge you and then some guys are waiting for you at the corner there. Then they pick you up again. So the nolle prosequi is actually that power that is given to the state, acting through the Attorney General, to say that for this particular matter, the state is not interested. And the law is couched in such a manner that it does not mandate the Attorney General to proffer any reason for his actions. So once he exercises it, that is the end of the matter. So I also indicated that the state can come back later and bring up charges against you. But there are certain circumstances where the effect of entry of nolle prosequi may be an acquittal and discharge. For example, if the state has closed its case, and then sometimes you want to enter the nolle prosequi at that stage, then the judge will say that, okay, once you have ended your case, the person has gone through trial and all that, some of the judges will exercise their discretion. Okay, then I'll acquit and discharge. Otherwise, the effect of it is just discharge. Now, the framers of the law, their wisdom was that, look, the president, who has the power of a prerogative of mercy, grant of pardon, etc., which he exercises at his will, acting through the Attorney General, so also have the power to truncate trials, sometimes for national interest. But the framers were very careful because some of the truncation, the reasons that could be given may infuriate the public. So the framers then were silent that don't provide any reasons.
Just do it.
Just do it. The reasons you know. So if an Attorney General assumes office and decides that he's going to provide reasons.
In the spirit of transparency.
In the spirit of transparency, he's going to provide reasons for entry of nolle prosequi. Then he's caught by Section 296 of the Constitution.
Which says discretion.
The exercise of discretionary power, which must be in accord with Article 296. If that exercise of discretionary power is capricious or it is having personal dislike and resentment against a particular person, interest, etc., then to that extent it's a nullity.
So the difficulty with Dominic Ayine's position is not because he has freed Dufour, but because he has explained.
Yes.
So the explanation now you are saying that is not sound.
Yes. So you see, let me tell you something. And I mean, he's one of the persons I must be honest with you, I have so much respect for him. And I rarely critique some of these things. But in this particular case, he gave himself out to the public, including me. If you give me opportunity to critique you, I will do it. Why not? If he had ended nolle prosequi in exercise of his power as Attorney General and left it at that in compliance with Article 88 as the man in charge of criminal prosecutions, and then Section 54 of the Procedure Act and etc., I have nothing else to say. I'll just go home and sleep, because the law has given him that power. Okay. But immediately you provide reasons, then we have to interrogate those reasons.
Would you say he should stop?
And that is what has led to this.
Would you say he should stop explaining?
I think that it is, he says it is in the interest of good governance. But I think that the more you explain, the more you muddy the waters. Because what he has done, the reason he has given, it makes people to think that it has become an incentive to commit crime. Look, Umaru, if I know that when I steal 1 billion Ghana cedis, and I'm caught, and I'm able to refund 600 million Ghana cedis, I'll go home with the rest. Why not?
Yeah, but
it's a big motivation, isn't it?
But there's a view too that what he has done is actually mirrored already in the existing law, the act that we passed, which says that you can plead to be guilty to something and then you pay the money and go home.
No, that's the plea bargain act. Yeah. And I've stated time and again that its history is also from Section 35 of the Act, the Courts Act. It's very clear from Section 35 that you can plead guilty, and the court will then, sometimes not only the money, they can impose a fine in addition to the money you are alleged to have stolen or embezzled or caused financial loss to the state. You plead guilty. But remember that the effect of that one is that you are an ex-convict.
Okay. Because you've admitted guilty, but only prosecutor you are not.
Yes.
Okay.
I mean, when you plead guilty, then you then say you're taking advantage of Section 35 or the Plea Bargaining Act. Okay. What it means is that we move a step forward and now say that there are consequential orders the judge will give.
What about the layman's view that, okay, they have brought Dr. Kwamna Dufo before court, he and some people. They say they want to prosecute and jail them. When they jail them, they will go to Nsawam. They may be given prerogative of mercy by the president. They will go home, free men, or they will save and will waste money on them. Now they have said that they will pay the money. Even if they are not paying everything, they are giving us some. Let's collect it and go home. What do you think of that?
Umaru, see, I'm saying that it is an incentive for people to go into white-collar crimes. They will use the pen tomorrow to do worse things. And I'm saying that we should not even argue about this. It's in error. Why? Because any exercise of discretionary power that would be to the detriment of the state ought not to be encouraged. Okay. Now, tomorrow, somebody commits a similar offense and pays 70%. You don't enter nolle prosequi. Are you complying with Article 296?
You're not.
You're not.
So there's precedent to guide you.
There's precedent. And that is the danger.
Okay.
Because it will mean that from now, based on the authority of the Republic versus Dufo and others, anybody who pays any amount can say that, look, I have done my best. I've paid 60%.
Let me
you
go.
Did this for, and what is good for the goose is definitely good for
the... Talking about the Ganda, let's talk about the Ganda now, and the Ganda being your client, Dr. Mustafa Abdul Hamid. Are you going to plead guilty so that you do a plea bargaining arrangement with the OSP because he's on your tail?
You see, I don't want to discuss the merits of the case.
Okay.
I can discuss that with you one-on-one outside of this program.
Okay.
But that case, just monitor it to the end. You report it live to the end and see the outcome. First of all, my client, I can say this because it's on record. And I know that it's not sub judice. In other words, it's not going to prejudice anything in court. Remember that my client pleaded not guilty to the counts against him, the 4 counts against him. He pleaded not guilty. So it is now incumbent on the SP to prove his guilt beyond reasonable doubt. And remember that he's facing 2 main charges of extortion and use of office for private gain. Go and read carefully Section 151 of the Criminal Offences Act and find out the ingredients of extortion. What it says. Using your office for private gain. Go and find out. Go and read the case in which some people were prosecuted for extortion with respect to Asamoah Gyan and matter. Go and read it. See the ingredient that were set up. And go and read that other matter. In fact, this matter is in public domain. Go and take the charges. Read them carefully and read the facts. And try to reconcile them. I'm not judging anything. But at the end of the day, justice will be served. Because remember, I have stated without number that the Vera Mustafa was initially hauled before the SP and he was being investigated for mismanagement and embezzlement of UPPF fund as Chief Executive Officer of MPA. But the charges now have nothing to do with that. He was cautioned on what I'm telling you, but the charges have absolutely nothing to do with mismanagement of UPPF fund. I even saw a very respected professor, a friend of mine, Kwiku Azan, saying that we are praising Mustafa for actually increasing the fund from about 51 million he inherited in 2021 to over 1 billion. And that we are praising him. What is wrong is wrong. Even if he has done that, the money was supposed to be more.
Okay.
But that's not what the SP is saying. The SP is not saying that he dipped his hand into UPPF fund and took any money. He said he extorted money from OMCs.
Very well.
That's the charge.
We need to leave it here and wish you all the best in court. Thank you so much for speaking to us.
Umaru, I'm grateful. Thanks to your esteemed house and for the honor. We are partners in this matter.
I forgot to ask if you ran for Timpani again.
The time is not due. When the time is due,
Okay.
when we get to the bridge, we shall cross.
When a politician says when we get to the bridge, we'll cross, it actually means he will cross the bridge, which means that he will run for Timpani.
Those are your words. Those are your words, not mine.
I am Omar Sanda.
I issue disclaimer that I have not taken any decision.
Please ignore his disclaimer. He will be running for Timpani. So MBP.
I issue disclaimer that I have not taken any decision about that.
Okay. My name is Omar Sanda, but this has been Face to Face. Thank you for watching us.